Module 3. Permitted Uses of Character Evidence. In this module, we investigate the subtleties of Rule 404 on character evidence. Though it's generally inadmissible, Rule 404's subsections delineate cases in which character evidence is admissible. Afterwards, we'll discuss the proper procedure for proving character evidence in court when allowed. Finally, we'll evaluate the limitations of relevance and discuss when otherwise relevant evidence is barred. Character evidence exceptions in criminal cases. Federal Rule 4042 allows a defendant in a criminal case to introduce evidence of his own pertinent character traits, which allows criminal defendants to bring witnesses as to good character. A pertinent character trait is a characteristic that relates either to the crime or a defense to the crime. For example, in a fraud case, the criminal defendant may call a witness to testify that he's an honest person. In a trial for a violent crime, such as homicide, battery, or assault, he may bring witnesses to testify that he's a peaceful person. Note, though, that the character evidence still must be relevant. In United States v. Nevado Ramirez, a police officer was charged with gun and drug possession. During her defense, she sought to introduce her police department performance evaluations to show her general competence at her job as a police officer. The court did not allow this character evidence to be admitted, reasoning that the character trait wasn't pertinent to the drug and gun possession crimes with which she was charged. Trial courts also retain power to limit the scope of proof by limiting the number of witnesses who can testify or the way proof of character is adduced. Once the defendant introduces evidence of a good character trait, the government may introduce pertinent character evidence to rebut the defendant's character evidence. The defendant's raising character evidence is thus sometimes referred to as opening the door to the use of character evidence against him. As Justice Robert H. Jackson wrote in the seminal Supreme Court decision Mickelson v. United States, the price a defendant must pay for attempting to prove his good name is to throw open the entire subject, which the law has kept closed for his benefit, and to make himself vulnerable where the law otherwise shields him. If a defendant does not open the door by making character an issue, the government cannot bring up the character evidence. For example, in United States v. Tran Trong Quang, wherein the defendant was charged with illegally prescribing drugs, the federal prosecutor asked one of the doctor's patients, "Is it fair to say that the defendant had a reputation in the community for being an easy source of drugs?" Because the defendant had never introduced character evidence regarding his reputation, the appellate court held that the witness's testimony violated Rule 404, and the question was improper. Rule 404A2 also permits the criminal defendant to introduce evidence of a pertinent character trait of the victim. This exception allows defendants in homicide or assault cases to show the victim's character trait of violence or aggression to support the defendant's claim of self-defense. Note that in both cases, character evidence can be established by testimony as to the reputation of the subject or the opinion of the witness. The party may not use evidence of specific instances of conduct to show that the person was more likely to act in a similar manner, unless an exception applies under Rule 404B, which we turn to next. Crimes, wrongs, and other acts for non-character purposes. Just as character evidence is not generally allowed, evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion that person acted in accordance with that character trait. However, Rule 404B2 provides exceptions where the evidence is offered for purposes other than to prove character. The rule provides 9 permitted non-character uses for introducing crimes or prior bad acts: motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, and lack of accident. If the prosecutor wants to provide past act evidence for one of the allowed purposes, she may be required to provide reasonable notice to the defense that she intends to do so. A court may also require her to describe the general nature of the past act evidence and to justify the reasoning behind seeking its admission. Let's look at some examples to illustrate when prior acts may be used for these enumerated purposes under Rule 404B. In Harris v. Barone, the plaintiff was an inmate at a prison who sued the prison for unreasonably keeping him confined to his cell for 82 days. The defense wanted to enter evidence of past instances when the plaintiff acted out, thus requiring discipline and special confinement. The plaintiff objected that this evidence of prior acts was inadmissible character evidence. However, the court allowed the evidence, ruling that the evidence was relevant to show that the prison security guards had a good motive for confining the plaintiff the way they did. In United States v. Slaughter, a defendant convicted of firearms possession appealed the admission of evidence relating to 2 other episodes where he possessed firearms and ammunition. The appellate court ruled that the evidence of prior possession of a weapon was relevant to prove that the defendant had an opportunity to be in possession of firearms in the present case and so was admissible. In United States v. Morin, Morin was charged with possession of a firearm as a felon, which required the intent to do so knowingly. The government introduced evidence that Morin had been previously convicted for the same crime. Because Morin claimed that he did not know the weapon was in his car, the court allowed the prior conviction to be admitted to prove that the defendant knew that he had the weapon. Identity is sometimes proven by showing that the crime was committed in a manner that is consistent with the defendant's modus operandi, often referred to by its initials MO. For example, if someone's on trial for robbing a liquor store and the prosecution wants to show that the person had robbed a liquor store in the past, that's inadmissible character evidence. But if the person's on trial for robbing a liquor store while wielding a Mossberg 500 shotgun and wearing a Richard Nixon mask and blue overalls on a Thursday evening at 10 p.m., and the prosecution wants to show that the defendant was responsible for 3 previous liquor store robberies, all around 10 p.m. on Thursdays, and all wielding Mossberg 500 shotguns and wearing Richard Nixon masks and blue overalls, this would likely be admissible. The prosecution is not merely trying to show the defendant's character. It's showing that this is the defendant's modus operandi, and thus that the person on the security footage, wielding a Mossberg 500 shotgun and wearing a Richard Nixon mask and blue overalls, was likely the defendant. It is being used to show his identity, not his character. Methods of proving character. While Rule 404 governs when character evidence is admissible, Rule 405 governs how it is proved when allowed. Rule 405 identifies 3 methods of proving character. The first is through a witness's testimony as to the person's reputation for a trait in the community. The second is through a witness with personal knowledge who can provide an opinion on a person's pertinent character trait. Third, a witness can testify about specific instances of the person's conduct from which a trier of fact can infer character. This last method is only allowed when character is in issue and is an essential element of a charge or claim. Reputation is the general community's outlook or view on a person. For a witness to be allowed to testify as to another's reputation, there are several criteria that must be satisfied. First, the witness must explain the foundation for her testimony. In other words, she needs to explain how she knows the person's reputation and explain the connection to the relevant community. For example, in United States v. Oliver, the court determined that a person's dorm roommates are appropriate sources of a person's reputation on a college campus. The dorm mates were acquainted with the college community because they lived on campus. They also knew of the victim's reputation through these interactions. Second, the reputation testimony must relate to a time that is contemporaneous with the events at issue in the litigation. The second method of proving character is for a witness to testify as to his opinion of the person. Witnesses testifying as to their opinions must lay the foundations for their opinions, meaning that the witness must explain how she knows the person and establish that she's sufficiently familiar with the person whose character is being proved. For example, in United States v. Gill, the defendant's character witness was not allowed to testify even though the witness had known the defendant's family for 20 years. Since it was not established that he had interacted with the defendant himself, the trial court was justified in excluding the opinion testimony. Finally, let's look at proving character evidence through specific instances of a person's conduct. Specific acts are admissible to prove character only when character is an element of the claim, charge, or defense. For example, assume a victim of a car accident files an action against a cab company for employing an incompetent driver. If the cab driver is an alcoholic, then his character is directly in issue, and the victim can introduce evidence of his specific prior acts of drunk driving to prove the negligence of hiring him as a cab driver. But if the driver's past actions were stealing money, that would not be admissible. While it's arguably negligent to hire a cab driver who has a record of theft, that has little or no bearing on the accident and injury in question. Evidence barred for public policy reasons. The federal rules of evidence lay out specific rules for certain types of evidence that are not admissible even though they're relevant. These types of evidence are barred to protect or promote public policy. Let's look at a few of these. Subsequent remedial measures. After a harmful event occurs, a person will sometimes act to ensure that the harmful event doesn't recur. This is called a subsequent remedial measure, and it isn't admissible in court to prove negligence, blameworthiness, a defective product or design, or the need for a warning or instruction. The purpose behind this rule is to avoid discouraging subsequent remedial measures. It's beneficial for society if an owner or manufacturer takes steps to prevent the occurrence of similar accidents or injuries in the future. Companies would be less likely to take effective remedial measures if such actions could then be used against them in a negligence action. Offer to compromise. Like subsequent remedial measures, offers to compromise cannot be used to prove or disprove the validity or amount of a claim. For something to qualify as an inadmissible offer to compromise, two requirements must be met. First, there must be a claim of liability. This claim can be a formal judicial claim, or it can be an informal claim. The second requirement is that there be some dispute about the validity of the claim or amount due. This can also be formal, such as a judicial response to the complaint, or informal. Any offer to compromise, when these requirements are met, is deemed inadmissible under Rule 408. It's beneficial for people to compromise and try to negotiate simple disputes out of the courtroom to maintain judicial efficiency. Allowing compromise negotiations to be used against the party would discourage negotiations. Offers to pay medical expenses. Under Rule 409, offers to pay medical expenses for an injury are not admissible to prove liability for the injury. This rule allows civil defendants to limit the potential damages they may incur. This rule encourages people to pay injury-related expenses and hopefully obviate the need for a lawsuit by removing the fear of judicial repercussions. Insurance. Whether a party is insured is not admissible to prove or disprove wrongful conduct. This rule was created to promote the public policy of obtaining insurance. Moreover, juries are supposed to decide cases based on their merits, not based on who will actually pay the damages. Evidence of insurance is admissible, however, for other purposes, such as proving bias or ownership of an item. For example, evidence that a person holds car insurance on a car is admissible to prove that he owns the car, or that he had a motive to be angry at someone who damaged the car. Sex offense cases and similar crimes. Prior acts regarding a person's sexual history are generally inadmissible. However, there are certain exceptions available when the case regards a sexual offense. These rules are contained in Federal Rules 412 through 415. Victim's sexual history. In a sex offense case, evidence of a victim's sexual history is generally not admissible. This is sometimes known as a rape shield law, and it prevents people accused of sexual assault from attacking the victim by accusing her of having been promiscuous in the past. This is designed to encourage victims to come forward and to prevent rape trials from degenerating into trials of the victims. However, in criminal cases, the victim's sexual history is admissible to show the source of physical evidence, such as sexual fluids and blood. Also, prior history with respect to the person accused can be offered to show consent. For example, evidence that two people have been involved in a consensual relationship for months can be used to refute a charge of forcible rape. Another exception is that in civil cases, the victim's sexual history is only admissible if the information's evidentiary value outweighs the risk of prejudice. The victim's sexual history may also be used in civil cases if the victim brings it up. Similar crimes in sex offense cases. In a prosecution for a sex offense, Federal Rule 413 allows the admission of evidence of similar crimes that the defendant has committed in the past. Rule 414 allows the same in criminal child molestation cases. Rule 415 allows the introduction of any prior sex offense evidence in civil sexual assault or child molestation cases. In our next module, we'll analyze other evidentiary issues, including authentication, identification, and evidentiary privileges.